Hello everyone and welcome to today's Television Education Network webinar. For technical assistance, please contact Redback Support on 1800 733 416. Or to listen to this video webinar through your phone instead, the dial-in number and passcode is listed below this video player. This video webinar is live and interactive. We ask you to participate by posting questions to the presenter by clicking on the dark blue hand icon located on the top right-hand corner of your screen. And finally, today's webinar materials can be accessed by clicking on the light blue arrow icon also located at the top right-hand corner of your screen.
Good afternoon, just hello there. Today we're going to talk about corporate oppression in a talk that I've labelled Oppression Proceedings under the Corporations Act, and we're going to work through the key legal imperatives in relation to that, hoping to bring you some value today on this topic. So before kicking off, I wanted to make a couple of preliminary comments to ground our discussion. And the reason I say a discussion of corporate oppression is very important, or perhaps one of the reasons, is that it represents a genuine existential threat to the company. A successful oppression suit can result in a wind-up. Your client, if it's the company, may not exist after an oppression suit. And so my hope today is that I'm able to ground you with a little bit more information on this topic in order to ensure your client exists on into the future. So it's that existential threat that I say makes a chat about oppression relevant and useful. What I say is that not only is it relevant for the advice that you might provide to companies, it's also going to be relevant for the advice that you provide to directors, board members, senior executives, these sorts of things. Now, as you know, companies have an almost unlimited range of conduct that they can engage in, meaning that within that unlimited range is conduct that can amount to oppression. So having made those preliminary comments, I just sort of wanted to give you the big three limbs of how our discussion today is going to work. The first part of our discussion, and I'll call it the hardest part of our discussion, is going to be the substantive law. It's going to be about Section 232 and Section 233 of the Corporations Act. And while it is an area of law I find very interesting, and I hope to convince you of that as we work through the discussion, there are some complexities to it, and there will be moments during our discussion of the law where our brains get a little bit twisted up and fuzzy. And we're going to emerge from part one with twisted up, fuzzy brains and moving on to part two, where we're going to work through some judicial examples. And what I say is that having fuzzed up our brains with a discussion about the law, we're hopefully going to organise that fuzz or deal with it somehow by crunching through some judicially considered decisions of how oppression works in practice, so that we're able to take our technical knowledge of the section and really put some meat on those bones with some examples. And the final part of our discussion today will be me making just a couple of practical suggestions for how you might address the threat of a corporate oppression suit in your practice. So let's get started. We're going to start with the operation, the nuts and bolts of Section 232 and 233 of the Corporations Act. Now, corporate oppression is described as the most effective minority shareholder remedy, or perhaps I should say it has been described that way. And that's not an inaccurate description, and it's not one I necessarily cavil with. But I should be really nice and clear for you in saying that it is not a cause of action merely available to minority shareholders. It certainly is available to the minority. It is also available to the majority, and it is also available to the entirety. So an oppression suit might be commenced by one of many hundreds of thousands of shareholders. It might be commenced by 49%, by 51%, by 99%, by 100% of the shareholders in a company. So it is important as a minority remedy, but it is not merely a minority corporate oppression is commercial unfairness. And we're going to figure out together what commercial unfairness means, and hopefully you're going to leave this talk with a clearer grasp on that slightly fuzzy term. So let's turn to the actual nuts and bolts operation of the legislation. The Section 232 is essentially our jurisdictional section. It sets out the criteria that might be met. And so what we have there is a set of criteria that the court must see satisfied in order to make an order pursuant to Section 233. What are those criteria? I'm not going to read the section out for you. That's a piece of good fun that you're able to enjoy yourself. What I will say is that the court may make a Section 233 order if it is satisfied that some past conduct, so some present conduct of the company's affairs, something that's happened in the past, or even a proposed act or omission of the company is contrary to the interest of the members as a whole, or some of the members, and that it was otherwise commercially unfair. Now, that's all a little bit fuzzy, so let me just try to bring a couple of matters to your attention. The court may make an order if that commercial unfairness test is satisfied. So there's a discretion there for the court. Secondly, I want to linger on the point for a moment that the commercial unfairness may relate to past conduct, present conduct, or indeed future conduct. So there's relevantly no real limitation on the sort of thing that might give rise to an oppression suit. And it's also worth lingering on the point that I made earlier, that conduct may be oppressive to one shareholder, 49%, 51%, 75%, 99%, 100%, whatever it might be, while the proportion of shareholders or members affected is going to be relevant. What I invite you to remember is that it's not merely a minority relief. Now, what is a 233 order, or what might it be? It might be any number of things. A Section 233 order might require that the company be wound up, might require that the constitution be modified. It might require a certain person to do a certain act or refrain from doing a certain act. A lot of technical things. It might require that some proceedings be instituted, some proceedings be defended, some proceedings be settled, whatever it might be. And it might indeed be a share sale. And while I don't want to spoil the ending too much, what I invite you to expect is that the court will often face itself in a tension essentially between if there's oppression and we want to make an order, is it a share sale or a wind-up? Let me just refresh our memory. Section 232, if there is commercial unfairness, the court may make a Section 233 order. Okay. This is going to make more sense the more we progress this conversation, I promise. So, what I invite you to take from that is that just as Section 232 has a broad range of conduct that might be commercially unfair, so does Section 233 have a broad palette of remedies from which the court may paint to order relief. Now, there are some relevant principles relating to oppression, and they were usefully summarised, respectfully, by Justice Austin in a decision called Tomanovich. We're not going to work through this precisely in nuts and bolts because when I get excited, I start to ruin microphones, I think. But the purpose of the relief in an oppression suit, which is to say, the purpose of our Section 233 order, if Section 232 commercial unfairness has been found, the purpose of that order is to terminate the oppression. So the court's attention will say, well, what is the oppressive cause? What is the thing that we need to stop? And if there's no oppression, if there's nothing going on, no matter how commercially unfair, no matter how Section 232 course of conduct might be, If there's no oppression arising from that unfair conduct, then there's no scope for the court to make 233 orders. So there can be very ugly conduct over here that if it does not cause continuing oppression that needs to be ended by the court, then there's no scope for a Section 233 order. What's also made clear in this judgment is that non-fulfilment of expectations, even really legitimate expectations, is not of itself going to be oppressive. And the judges hearing matters like this must be live to the possibility that the minority, the plaintiffs in an oppression suit who are complaining about commercial unfairness, may have, by their conduct, baited the alleged oppressors into their allegedly oppressive conduct. I imagine this is all still feeling fairly crunchy for you. It will continue to for a little longer, and then we're going to see the light of day, I promise. So at paragraph 22 of a decision called Munsterman and Raywood that we'll turn to a little later in this discussion, Justice Stevenson works through what I consider to be, respectfully, a really useful set of criteria for looking at oppression suits. Courts have to work through on the balance of probabilities, whether the objective bystander would be satisfied that the affairs of the company are being conducted unfairly. A director can be acting oppressively in the Section 232 sense of commercial unfairness and not otherwise breach directors' duties under the Corps Act or the fiduciary duty, their directors' duties that arise from their fiduciary obligations, which is to say, oppressive conduct can be oppressive, notwithstanding the fact it's otherwise lawful, if that makes sense, which I hope it does. And that's a point I'll linger on. While it's true for directors, it's true for the company more broadly. So there can be behaviour of a company that is commercially unfair, which is to say oppressive, if we're speaking loosely, commercially unfair in that Section 232 sense, but it is otherwise lawful. Hope that's clear. Conduct that has the effect of paralysing a company from engaging in its tasks is contrary to the interests of members of the company, and it is therefore oppressive. Now, I'd like to linger on a point regarding timing. In relation to timing, when the court is considering an oppression suit, the question of is the conduct oppressive, which is to say, in our Section 232 formulation, is the conduct commercially unfair? That question is to be answered at the time proceedings are commenced. So we commence proceedings 1 January 2020. The question when we go to hearing in late 2021 is essentially, was it, it's not quite framed that way, but I'll plant the issue in your head, is there commercial unfairness as at the time proceedings are instituted? Second issue in relation to timing is 233. Because remember, the purpose of a 233 order is to cure the oppression. And so the court must turn its attention at the time of considering making an order, at the time of final hearing, to saying, right, when the proceedings were instituted, there was 232 unfairness. Now that we've found that, and it's the final day of the hearing, 18 months, 24 months on, perhaps longer, is there oppression for us to cure? Is there a target for us to attack using the Section 233 palette of remedies? So I'll reinforce that timing point. The 233 question is, was there commercial unfairness at the time proceedings began? The 233 question is, what's the right remedy now that everything's been heard at the end? Does that make sense? Hope it does. Okay. The court is generally going to seek the least intrusive relief. And the aim of the remedy, as you know, is to end the oppression. And there's a suggestion made in this judgment that I'm going to add a gloss to later today, but there's a suggestion made that the winding up of a company ought to properly be seen as a last resort, because as you can imagine, that's a reasonably intrusive form of relief. And so what is suggested, and I'll develop on this later, but what is suggested is that the wind-up of a company might be seen as a last resort. And if a share sale is ordered, then the court ought to fix a price that is a fair value in all the circumstances. So if you've dived into the issue about fair value versus market value and had your brain twisted around and now you understand the outcome of that discussion, you'll know that it's a fair value issue. Okay. That was the hard bit. I'll have a sip of water if you'll forgive me. And I feel like there's every chance your brain might be a little bit twisted around and sort of thinking, well, what is commercial unfairness? What are we really talking about here? Before going on, I just want to linger on this point I've spent a little time on already. Section 232, was there commercial unfairness? If so, the court may make a Section 233 order. I suspect you agree with that opening proposition that commercial unfairness is sufficiently vague to trouble lawyers, let alone lay people. And so what I say is working through some examples is going to assist us. Now, one of the interesting elements that I suspect you will understand after a moment's thought is that oppression generally relates to smaller proprietary companies rather than larger public companies. And this stands to reason. If I'm a disappointed shareholder in Blogsy & Co. Pty Limited, the company that my brother and I use to operate several fruit and vegetable shops, then it's going to be more difficult for me to untangle myself from that relationship than if I were a shareholder in BHP. And so the degree to which I am oppressed by the conduct of the board of BHP or whomever it might be is going to be vastly lower than the degree to which I'm oppressed by the conduct of Blogsy & Co. Pty Limited, where I'm one of the only two shareholders. I suspect that stands to reason for you, and as we work through the examples, you'll see that that's a recurring theme. So what's some conduct, speaking in short, that has amounted to corporate oppression? Just to give some quick examples to ground us. The use of mini board meetings prior to actual board meetings to determine how the majority is going to vote in the board meeting. Excluding directors from the management of the company when they might have had a very reasonable basis for expecting to be included. Payment of excessive salaries to directors. In some circumstances, if I can linger for a moment, what you're going to find is that phrase, in some circumstances, is going to become a sort of guiding light for us as we work through these examples, because the conduct we're talking about will be oppressive in some circumstances, which is to say, in the circumstances we'll be working through. So in some circumstances, the inability of a minority to sell their shares may be oppressive. And in some circumstances, the failure to investigate irregular payments might, or otherwise prosecute an action, might end up being oppressive. So let's dive into some nuts and bolts as we head down to or up to or east to or west to our nation's capital in sunny Canberra. We have a corporation, and what the corporation does is it operates an eye hospital. And the corporation has a number of directors and a number of shareholders. Relevantly for our discussion, each of the shareholders is an eye surgeon who is performing eye surgery at the company's hospital. And so the company's whole model is essentially cause eye surgeons to perform surgery, generate income via eye surgery, and distribute the income to shareholders. Things tick over quite well for a little while, and after some time passes, the minority shareholders retire, And off they head. They remain shareholders of the corporation, and the corporation continues to operate the eye hospital. But the retired, I'll use retired as the terminology, shareholders were no longer performing eye surgery. They're off on the golf course, or they're in Jarvis Bay, or wherever Canberran eye surgeons retire to. And they continue to derive what we might describe as a passive income because they remain shareholders. Now, what is the source of that income? It is the exertions of the majority who remain hard at work in the eye hospital performing eye surgeries. As you might imagine, the relationship between our retired minority and our still working majority it doesn't remain healthy forever, and the relationship breaks down. Our majority appoints 2 directors who are sympathetic to its plight. Now, it is the conduct of these majority directors that we're concerned with today. So what do? Well, they stymie the appointment of a new surgeon who, notwithstanding the fact the company is solvent, the appointment of that new surgeon could really bring the company back to operating at a high level and secure its future. So they really stymie that for strange, fiddly reasons. They pick holes in an understandable mistake made in the candidate's application form. They cause delays, which the court finds are unreasonable, and generally they stand in the way of this candidate becoming an accredited eye surgeon and therefore able to go to work in the eye hospital and therefore generate income. The other thing that the what I'll call the majority directors, the directors appointed by the majority do, is they cause the company to be placed into voluntary administration, notwithstanding the fact that it remains solvent. So what happens next? During the during the voluntary administration, our minority shareholders sell their shares in the company to the majority for the amount of a little bit over 1.7 million, and they also take a payment of their proportion of the stock of the company. So they've sold their shares, they've got their money, but they nonetheless march on with their oppression claim. And what the court finds is that the stymieing of the appointment of that director and the placing of the company into VA, notwithstanding its solvency, was oppressive. Section 232, was it oppressive? Tick, yes. So now we turn to Section 233 and say, right, now that the court has found commercial unfairness, it may make a Section 233 order. And let's refresh our memory. The purpose of a Section 233 order is to cure the oppression. And so what the court does is turn to a valuation of the minority's shares. And it crunches through a lot of evidence in relation to that valuation and says, well, the amount, the 1.7 million or so that the minority received is actually in excess of the fair value of those shares. And so our minority can now be seen to have enjoyed something of a windfall. And so our minority can be seen not to have suffered as a result of the oppressive conduct. And so there is no oppression for the court to cure. And so no Section 233 order is made, despite the Section 232 oppression. There was a separate judgment on costs. And what the plaintiff said, in essence, is we got up. We proved the overwhelming issue that the conduct was oppressive, and so we should get our costs or a significant proportion of them. And what the majority said, didn't have to say it at too much length, was you were seeking orders pursuant to Section 233, you didn't get them, costs follow the event. In short, that was accepted and that was the outcome. And so we have our minority shareholders who prove commercial unfairness, unable to show they are being oppressed, and so unable to provide a basis for getting a Section 233 order, and so being sent packing with a cost order against them. Knight's Quest. And before proceeding with this one, what I should say, and you might be able to see me glancing over at the clock from time to time, is that I'm endeavouring to budget a little bit of time for questions. So if any of this discussion gives rise to a question for you, please feel free to ping in that question using the interface that I understand you have in front of you. Right, Knight's Quest. We're talking about wine in a can, which I understand may or may not be the best way to drink wine, and that this is an available dispute amongst wine people. But in any case, we have an Australian company that makes wine. We have a Japanese company that manufactures cans for the storage of wine in a can. And a few years ago, these companies enter into an agreement. The outcome of that agreement is that our Japanese manufacturer becomes a 60% shareholder in the Australian winemaker, and other commercial elements as well, including a duty of good faith. Now, what is also known to all parties and relevant for us is that the Japanese can manufacturer has a subsidiary that is itself a winemaker. And in the markets of China and Japan, the Australian winemaker and the Japanese subsidiary compete against each other. There's also an argument from the Australian wine manufacturer that a patent or a piece of intellectual property it has relating to canning techniques is being used by the Japanese subsidiary, and license fees ought to be paid in respect of those and are not. And as you can probably get a sense of, all these issues become a little bit crunchy, and our Japanese can manufacturer applies to wind up the Australian entity, and following that, our minority shareholder in the Australian company, so our Japanese can manufacturer owns 60%, our 40% shareholder over here then alleges that this conduct is oppressive and says that the conduct of the Japanese can manufacturer is oppressive in relation to these license fees failing to be paid, and in relation to the arrangement with the subsidiary competing with the Australian company. Now, working through the facts and working through a great Scottish decision of the 1950s about the manufacture of rayon, what the court essentially finds is that the conduct of the can-making entity, the Uber entity, including its knowledge of the conduct of the Japanese subsidiary and its possible competition with the Australian winemaker, was not in and of itself oppression. And so our 40% shareholder in the Australian wine manufacturer was unable to prove that that was Section 232, commercially unfair. And I didn't follow along with the slides there. I got a bit too excited because it's an interesting decision. But it's that final bullet there, that fundamental point, that working through all of the relevant facts, working through what the parties knew at the relevant time, working through the implications of the term of good faith, the court found that there was no oppression made out, meaning that there was no commercial unfairness pursuant to Section 232, and meaning the court's attention didn't even need to turn to Section 233. That finding was challenged unsuccessfully on appeal. A tale of two golf clubs. At the time of this judgment, reading between the lines a little bit, there were financial difficulties for a couple of golf clubs, and in order to secure their financial future, their respective financial futures, there was a resolution that these two entities ought to merge. The way that merger was to operate in a technical sense was for a newly merged club to arise from the ashes was for only one golf club premises to remain after the merger and for the other golf club premises to be sold for residential development. The proceeds from the sale of that golf club come to ensure the financial stability of the newly merged entity. Hopefully that makes sense. It certainly did to the relevant parties. Now, part of that merger includes the members of Golf Club X coming over to become members of Golf Club Y, the newly merged Golf Club Y. Members from over here become members over here. Now, the plaintiff in these oppression proceedings commences them in an attempt to essentially unwind the merger and unwind these transactions. What happens is that at first instance, the court finds that the directors of the newly merged entity exercised the power they had from the Constitution to admit new members for reasons other than the reasons that that power was granted to them. Makes sense? So they had the power to do it, but the reason they did it was for a reason alien to the reason the power was there. It wasn't a power about mergers, it was a power about other things. And so what the first instance judge held was that that was oppressive, and it continued to be so. This satisfies 232. This satisfies our commercial unfairness. And having been so satisfied, the court may make a Section 233 order. This is the next possibility. And so the court exercises its discretion to refuse relief. And on appeal, that Section 233 refusal is upheld. Why? Now, the basis for it is that the plaintiff had taken time to bring his application, and that as a result of the delay and as a result of the various other facts that had unfolded over time, which, as you can imagine, the merger of these two golf clubs is a reasonably complicated process with a number of steps. By reason of that delay, by reason of acquiescence, the plaintiff was not granted Section 233 relief, notwithstanding the fact Section 232, commercial unfairness, was indeed found. This was upheld on appeal. And there's just a little side note. Is part of the process of running the appeal, the plaintiff sought to join the purchaser of this golf club in order to try to unravel that transaction as well. And the application for joinder was heard by the Court of Appeal, and that application was not granted. I will repeat my invitation to you as well, that if there are issues, if you've got matters you'd like to discuss or ask about, do feel free to use the technology in front of you to ask those questions. All right. So we've had to think about Section 232, commercial unfairness. Now let's drill into Section 233 a little bit. And if I can plant in the back of your mind an issue that I might have mentioned earlier, and I recall mentioning it earlier, of a comparison between a share sale and a wind-up as Section 233 relief. Put another way, is a wind-up truly the quote, last resort of the court in considering these issues? We've got a complex dispute, and it relates to mining parties. At first instance, the plaintiffs, the relevant plaintiffs, they get up on Section 232. They prove that there was commercial unfairness, which enlivens the court's discretion to make a 233 order. The court considers all the relevant facts and particularly considers the fact that the relationship between the shareholders and directors was a quasi-partnership. It really required close, trusting relationships. That's fundamental to the way it's operating. Those close, trusting relationships are gone. And so commercial unfairness was found, and sorry, the point I was coming to there, or intended to come to, was that the appropriate Section 233 order was for the company to be wound up. Now, our unsuccessful defendant appeals. The basis of that appeal is to say, you got me, essentially, in relation to Section 232 commercial unfairness. There is an acceptance of that finding. The challenge is made to the form of Section 233 relief, and this is the challenge that the unsuccessful defendant brings. The unsuccessful defendant would prefer a buyout. Now, in considering this stuff, the court gave consideration to Section 467 sub 4 of the Corps Act about the making of a wind-up order, and it also gave thought to that point that I hope I made reasonably clear at an earlier stage, that a wind-up might be thought of as a last resort. And so the question the court is confronted with is, well, is a wind-up literally the last resort? Do we have to find that every single other possible mode of relief available pursuant to Section 233 is exhausted and inappropriate, and is it only after we do that we consider a wind-up? The short answer to that is no. What the court finds is that, look, a wind-up is indeed an extreme step. There is the investment made by shareholders. There's the risk of serious difficulties being caused to employees, third parties, and a wind-up ought to be treated as an extreme step, but ought not be treated, technically speaking, as a last resort. If there are issues, if there are 232 issues that can only be resolved with a wind-up, then proceeding to a wind-up is not unreasonable. And what the court found is that it was an extreme step, and indeed an extreme step that it was appropriate to take in these proceedings. There are a number of reasons for this. Firstly, valuation of the shares, the valuation that will be necessary to have a share buyout or a share sale, depending on what side of the transaction you're thinking about, that'd be extensive, expensive and time-consuming. How are we going to decide on the value of these shares? And one of the issues is that there is a $33 million unlitigated claim for a breach of contract. So the question is, well, how are we going to value a chosen action for this quantum when we're thinking about the value of the company? The answer to that is with complexity and difficulty. So that's one matter standing in the way of a share sale and in favour of a wind-up. There are doubts about the appellant, or the defendant in the first instance judgment. There are doubts about the defendant's ability to pay a share sale. As you can imagine, the shares will be of some considerable value if we're taking one $33 million asset into account. And we don't quite know what the outcome of that calculation will be, but it's a reasonable expectation and inference drawn, I think, by the court that the shares are going to cost a reasonable amount of money, and it's unclear. There's no evidence before us to conclude that the appellant has capacity to pay. And while the possibility was raised that there might be, for want of a better word, parent entity, one of a better phrase, parent entities, who might stand behind the appellant to fund such a purchase, there was no such guarantee offered that could give the court comfort to say, right, great, we've got our guarantee, we can proceed with a share sale. So on the basis that this quasi-partnership, that the appropriate relief for the quasi-partnership looked like being a wind-up, on the basis that a wind-up was not necessarily a last resort in the technical sense, but was extreme, working through the relevant facts relating to a share sale, the court considered the appropriate path was to order the wind-up. Hunter and Organic, 5 individuals. They are the shareholders of a company that operates in the organics retail space. There are 3 directors selected from the 5 individuals, and we're going to turn these 5 individuals into 3 groups. It sounds a bit strange. There's a husband and wife group, there's another husband and wife group, and there's a 5th individual who, for the sake of argument, we'll sort of refer to him as a group as well. And in short, things go well for the organics entity, and there's a restructure in 2006. And the aim of the restructure is to formalise the payments made coming out of this retail business, to protect the assets of the business and to minimise tax. What's the outcome? Let me take a few moments to describe this. Our trading entity transfers the IP and the know-how in the operation of the business over to a newly incorporated entity. That newly incorporated entity is the trustee of a trust. And it holds on trust for each of the family trust discretionary trustees of our 3 groups. So one husband and wife group is one. So the family trustee for one husband and wife group is one beneficiary of the new entity's trust. One husband and wife group is the beneficiary of another, and this sort of individual person group is the beneficiary of another. Right? How do we get the money out? Well, our new entity charges licence fees to the trading entity that coincidentally happen to be about the same quantum as the profits being made by the trading entity. So the trading entity is trading, paying out the profits by way of a licence fee. Licence fee comes into this new entity here. New entity holds it on trust for each of the family trustees and then flows down to the individuals through that entity. I hope that makes sense. The restructure was undertaken pursuant to advice. As you can imagine, there was some complexity to it. And we now turn to the proceedings. The terms of the family trust that is relevant for us require that our beneficiaries, so we're dealing with a husband and wife here, spouses, the spouse, the particular spouse, the wife that we're dealing with in relation to this trust, her entitlement to discretionary distribution from this family trust is contingent upon her remaining married to the husband. And so now that the only way of getting cash out of this whole arrangement is by licence fees being paid this way, held on trust for family discretionary trustees and paid out through this family trust, and now that our for want of a better phrase, our poor old wife is no longer married to the husband, meaning she no longer has any entitlement to any money from these discretionary trusts, she now went from being, before the restructure, a 20% shareholder in a trading entity, so her shares were of value. But after the restructure, she holds shares in this thing that no longer has any value. She has no entitlement to discretionary distributions from the family trust. And so she says, well, I've been oppressed. This is oppressive. I formerly had this entitlement. I no longer do. I'm going to commence proceedings. And what the court found was that's wrong. Because in order to succeed in an oppression suit, what needs to be proven by the successful applicant is that the conduct was oppressive, was commercially unfair, I should say, to be more technical. What our plaintiff was saying was the outcome is unfair, the outcome is unfair, and the court might have had some sympathy with that, but the position was, regardless of the fairness of the outcome or otherwise, it is the conduct that must be turned to. And in circumstances where the plaintiff's chief complaint was, I used to have something valuable and now I don't because of a restructure, because she took advice and signed up and can be taken to have understood what was going on, there was no conduct for her to direct or her to effectively direct her oppression suit towards, meaning that there was no success in the oppression proceedings. No oppressive conduct means no successful oppression claim. And for anyone concerned about the plaintiff's financial well-being, there is a notation made in the decision that she remains free to pursue her rights pursuant to family law, and we can reasonably expect that she did that. Our final example for today, I'm going to move through this marginally quicker than I have the others because I'm conscious of the demands on your time and I'd like to get to the practical points shortly. But I will also repeat my invitation for questions. Consider the floor open. This is a decision called Munsterman and Raywood. And what we have is a solvent company that is operating a business in Queensland. The company has over 10 employees. We have one director up in Queensland who is there working on the business, doing stuff. The managing director working away there. And we have another director in Sydney, 2 directors, and each of these directors is a 50-50 shareholder. Right. An irreconcilable deadlock arises following a request from the Sydney director that the Brisbane director buy out his shares at a certain price. That offer is not accepted, and so the defendant, our Sydney director, engages in what might be perhaps not unreasonably described as colourful conduct, but conduct that, just to spoil the ending for you, certainly was commercially unfair. So our defendant, our Sydney director, attempted to be reinstated as financial controller when that role is being performed and performed capably by others, issuing an invoice for $16,000 of work that was neither requested nor actually done in a course of conduct that the Sydney director accepted in cross-examination was a try-on at the expense of the company, attempting to set himself an unjustified salary, requiring that payments for minor items, including staples, be approved at minuted directors' meetings, sending an all-staff email which inaccurately suggested the company had insufficient funds to pay wages and super, and generally, and this is a proposition accepted in cross-examination, holding the company to ransom. As you can imagine, the court did not have too much difficulty in forming the view that the conduct we've just described was commercially unfair, 232, meaning that the court's discretion to make a 233 order is enlivened. The 233 order that the court considered appropriate was a share sale pursuant to a valuation, and that is what happened. And what you might say is, well, wasn't a share sale what our misbehaving Sydney director was after in the first place? The answer to that is maybe, but, and I say this respectfully, I think there's every chance that the share sale pursuant to the court-ordered valuation may not quite be at the quantum that the Sydney director had hoped. So, I hope, after I have a sip of water, that you now have a sort of clearer understanding of that fuzzy law. Remember, we started our discussion off with that fuzzy Section 232 and Section 233 of the Corps Act. We spoke about commercial unfairness, and what I would like you to have taken from that is that there's a real broad range of conduct that can be commercially unfair, and as a result of that broad range of conduct, the court has a discretion whereby it may make an order pursuant to Section 233, and an order pursuant to Section 233, there's a broad palette of remedies from which the court can paint. So, from the law, lots of conduct can be commercially unfair, lots of orders can be made. And then we worked through our examples, and what I hope you took from those was, I guess, a clearer understanding of commercial unfairness, perhaps a clearer understanding of the really wide range of circumstances that can lead to commercial oppression. And what you might find is that conduct that might feel unfair is not always oppressive. That sort of management and control can often motivate a plaintiff in commencing the proceedings, or a defendant in defending them, or parties to a dispute from engaging in that dispute. And I think the heart of it, where we're just about to come to when we get to some practical suggestions, is that the real issue is, well, a lot of these arise from there being no exit strategy for our relevant parties. That's something we're going to come to in a moment. And I'll just finally say, on this particular slide, and without disrespect, often there's a personal animosity element to these proceedings. I pause there for a moment because I'm very grateful to have received a question. Kirsty, thank you. Kirsty asks, what do you think the court's attitude would be to an employee fired from a company, then unable to sell their minority shareholding back to the company because the shareholders' agreement doesn't provide for an automatic share sale? It's a really, really good question. So we've got an employed shareholder, the employed shareholder's fired, looking to sell the shares back, but the shareholders' agreement doesn't provide for it. Kirsty, I'm just about to come to that practical point, and the short answer is there may well be an oppressive element to it, but often the mere inability of a minority shareholder to sell their shares may not in and of itself constitute oppression. So while I don't want to dive too deeply into a hypothetical, if this is a situation you're finding your client might be in, now is the time to bring them in for a meeting of a couple of hours and to ask them to print off all their emails, all their documents, and sit down with them and work through what evidence we can put together, you can put together, to start thinking about how we're going to prove this commercial unfairness point. Because there's every chance you can. The defence may well be, well, what is the oppression? Sorry, I withdraw that. What is the current oppression, and so what relief ought to be ordered? And your client may well say to you, well, I want a share sale, I want to get out of here. And then frankly, sorry, that is precisely the question you asked. So I hope that preliminary suggestion to you of get the evidence in, and yes, there is a chance that the conduct you describe is oppressive, assists. The other practical suggestion I'd make is a shareholders agreement that includes terms that protect our clients in the relevant scenarios that we might be able to anticipate. And obviously we can't anticipate every scenario, as Kirsty very kindly provided an example of just there. So when is the best time to make a shareholders agreement? 20 years ago, or the incorporation of the company is the answer to that. When's the next best time? Today. And so if your client comes to you with what may feel like an oppression suit, and in fact, Kirsty, this might be relevant to you, an agreement can be reached that may well be, in essence, a shareholders agreement, but it is a shareholders agreement reached at a time of tension rather than at a time of inception of the entity. And so if there's oppressive stuff going on, enter into a shareholders agreement or litigate. They're about our two options. And so let me work through just a couple of points that shareholders agreement may address. And I'm conscious of not taking up any more of your time than I need to. So we want our shareholders agreement to deal with accession. How are we bringing new shareholders into the fold? We want to deal with management structure that I think I refer to as chain of command in the paper. You know, we want to understand who has to listen to who. Buy, sell provisions. Kirsty's client would be grateful, I think, if she or he or it or they were equipped with a shareholders agreement that had a nice clear mechanism for getting shares out. We want to deal with how capital contribution works. When can shareholders or directors be required to be contributing capital? We want to understand how share transfers are going to work. Are they going to be restricted? Are they not? We want to, and I think this almost comes to the heart of today's discussion, we want to have a dispute resolution clause. We want to know what happens when the proverbial hits the fan. We want to understand what are the steps that our shareholders ought to work through in order to deal with this stuff. We want to set out how meetings are going to take place. We want to know how to resolve disputes. we want to consider whether we want to regulate payment of dividends, because as you may recall, the non-payment of dividends is not often sufficient to ground an oppression suit. And so if dividend payments are important to your clients, then that is something that ought to be considered in the shareholders agreement. And something that's often lost, and I expect this is true from your experience as well, is a shareholders agreement without a business plan. And even though as lawyers, we're not really business plan draftspeople, incorporating a business plan of, look, what is it the entity's actually trying to do? And of course that ought to be, well, perhaps in days gone by, that would have been better covered in the Constitution than it may be these days. And so there may be value in setting out, look, we're a corporation that does blah. Let's all agree that that's what this entity is for. And I then return to my previous point of, look, if there is oppressive conduct, we either agree and we record that agreement, and that agreement may have terms the same as or similar to those I've set out above, or litigate. And there might be some commercial practitioners among you that say, yes, yes, agreement, let me get drafting. There may be some litigators among us that say, no, let's go approach the court for some relief. They're the two possibilities we look at when we start looking at oppressive conduct. And that is about as far as I'd intended to take today's discussion. So I'll briefly reissue my invitation to ask any questions you might have, but I might just reflect for a moment before leaving you on what I intended to achieve today and what I hope we achieved today, or at least took some steps towards it. What I hope is that we spent some good time going through the muck and the mire of the legislation relating to corporate oppression, and we emerged with a clear understanding of Section 232, commercial unfairness. If found, the court may make 233 orders, from which, and there are a wide number. And then from our examples, we may have thought, well, there's a lot of different kinds of commercial unfairness. Will there be a share sale? Will there be a wind-up? Will there be some other relief? Will there be no relief at all? These might be questions that will inform you as you advise your clients. And then we talked through some practical suggestions that could be boiled down to 4 words. I think of get a shareholders agreement. And with that hopefully clear and reasonably firm suggestion, what I'd like to do is thank you so much for your time. This is an area that, as you can probably see transparently, that I enjoy talking about, and I hope I brought some value, perhaps a little bit of pleasure to you as well. I wish you the very best for your day.
Thank you everyone for participating in today's video webinar. As a reminder, we ask that you provide your feedback by completing our short survey by clicking on the yellow Provide Feedback icon located on the top right-hand corner of your screen. Your feedback can now be provided for the next 10 minutes. Today's webinar materials can be accessed by clicking on the light blue arrow icon located on the top right-hand corner of your screen. We thank you in advance for your feedback, and we hope to see you at another Television Education Network presentation soon.